Okay, I'm going to go ahead and get started. It looks like people were able to come in from the waiting room. Good afternoon, everyone. Thanks for joining us over your lunch today. My name's Jack Devine. I'm an associate here at KMCL Law in Midtown. I practice environmental law, and today I'm going to be joined by Professor Mindy Goldstein from Emory, Professor Eric Siegel from GSU, and April Lipscomb from SELC. We're going to be talking to you about a couple Supreme Court cases and the impacts that those might have on environmental law and administrative law in the near future. So by way of quick introductions, Mindy Goldstein is a clinical professor of law and the director of the Turner Environmental Law Clinic and the director of the Environmental and Natural Resources Law Program at Emory University. Mindy's represented clients in complex environmental litigation before judicial and administrative tribunals and legislative and policy matters at the local, state, and federal levels, and in land use, food systems, and other environmental transactions. Her representations have been covered extensively by the media, including AJC, Boston Globe, Chicago Tribune, E&E News, The Economist, The Hill, Law 360, and others. Mindy is a senior faculty fellow with Emory University Center for Ethics, a faculty fellow with Emory's Office of Sustainability Initiatives, and a member of the Institute of Georgia Environmental Leadership. Next, Professor Eric J. Siegel graduated from Emory University, Phi Beta Kappa, and summa cum laude, and from Vanderbilt Law School, where he was the research editor for the Law Review and member of the Order of the Coif. Professor Siegel clerked for Chief Judge Charles Moy Jr. for the Northern District of Georgia and Albert J. Henderson of the 11th Circuit Court of Appeals. After his clerkships, Siegel worked for Gibson, Dunn, and Crutcher and the U.S. Department of Justice before joining the Georgia State faculty in 1991. Professor Siegel teaches federal courts and constitutional law 1 and 2. He's the author of the books Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. His articles on constitutional law have appeared in, amongst others, the Harvard Law Forum, the Stanford Law Review, UCLA Law Review, the George Washington Law Review, Washington University Law Review, amongst others. And then finally, we are joined by April Lipscomb from SELC. And as a seasoned litigator, April represents partner organizations who are fighting for clean water, environmental justice, and proper handling of solid and hazardous waste. As a leader of the Georgia Water Coalition, a powerful group of advocates who work to protect Georgia's water resources, April recommends strategy and provides legal analysis to its member organizations. April also lobbies state and local officials on behalf of SELC and the Georgia Water Coalition and advocates for more stringent permits and regulations for the State Environmental Protection Division and Department of Natural Resources Board. So now that introductions are out of the way, we will dive right in. The first case that we'll be covering today is Securities and Exchange Commission versus Jarkesy, and that's not pronounced Jarkesy, as I've been incorrectly doing for a few months now. I found a radio transmission of him last night and found out that the correct way to pronounce his name. So I apologize to Mr. Jarkesy. So just getting started, the question presented in that case was whether the Seventh Amendment entitles a defendant to a jury trial when the SEC seeks civil penalties for securities fraud. Moving on to the legal background, I'm just going to lay some groundwork here so we understand the legal situation. So in the aftermath of 1929, Congress passed a bevy of laws to combat securities fraud. Those were the Securities Act of 1933, the Securities Exchange Act of 1934, and the Investment Advisors Act of 1940. The anti-fraud provision of each targets the same basic behavior or misbehavior, misrepresenting or concealing material facts. Congress then created the SEC to enforce these laws, and the SEC can either prosecute in court or in-house, and the forum there is important as it determines much of the procedure. The biggest procedural difference there being that in a court, a jury decides questions of fact and a judge presides, whereas in-house, the commission presides and finds facts, while another wing of the same agency prosecutes those claims. Previously, the SEC could only obtain civil penalties in court, but then Dodd-Frank was passed in 2013. And one of the big things that Dodd-Frank did was allow the SEC to seek civil penalties from in-house adjudications. And the SEC can fine you up to $725,000 per violation. Moving on to the specific facts here. Between 2007 and 2010, George Jarkesy Jr. launched 2 investment funds. He raised about $24 million from 125 accredited investors. In 2013, the SEC initiated an enforcement action against Mr. Jarkesy, and his company Patriot 28 LLC. They alleged a series of fraudulent behaviors. He misrepresented facts about the funds in order to basically make more money through management fees. The SEC decided to adjudicate the matter itself under Dodd-Frank, and then it ended up levying around $300,000 in fines, as well as barring Mr. Jarkesy from participating in the securities markets moving forward. The Fifth Circuit reversed that decision, saying that the in-house adjudication violated the Seventh Amendment because the action had originally been brought in an Article III court. A jury would have been required, and something we'll explore called the public rights exception doesn't actually apply here. So moving on to the reasoning, the court pronounced that the action implicates the Seventh Amendment and it does not fall within the public rights doctrine, and therefore the Seventh Amendment entitles a defendant to a jury trial and the SEC seeks civil penalties for fraud. So the Seventh Amendment, historically, the right to a jury trial has been afforded unique protections in the US. This is due to abuses by the crown in the 18th and 17th century. The Seventh Amendment guarantees a jury trial for suits at quote unquote common law. The Supreme Court has since interpreted that to extend to claims that were not common law forms of action at the time of the amendment. The Seventh Amendment also extends to certain statutory claims if they are, quote, legal in nature. Under the Toll decision from 1987, a court looks to the remedy sought to determine if an action is legal in nature. In Toll, a Clean Water Act prosecution was determined to be legal in nature, regardless of its statutory basis, because actions by the government to recover civil penalties under statutory provisions are historically viewed as a type of action in debt requiring a jury. The court says the same is true here. The SEC is seeking civil penalties. That's a form of monetary relief. The monetary relief here is legal because it aims to punish and deter and not simply to restore the status quo, which would be more of an equitable remedy. Civil penalties are available under the Securities Exchange Act and the Investment Advisors Act based on 6 factors. And when you go look at those 6 factors, it becomes very clear that this is a punishment and it's not really meant to restore a victim. The SEC is finally also not required to turn over any of the penalty to those that were harmed. And those things together, the court interpreted as showing that this is a punitive penalty and therefore it's a legal remedy. The public rights exception, the Constitution generally prohibits Congress from taking away common law adjudications from Article III courts, but that's not always the case. Article III courts need not be involved in the adjudication of public rights claims, which are those which historically could have been determined exclusively by the executive and legislative branches. This goes back to the Murray-Lessee case from 1856, which established, or in which the court determined that the government could issue a distress warrant requiring a federal customs collector to hand over collected funds without involving an Article III court pursuant to the power to collect revenue. The government could rely on summary proceedings to compel its officers to hand over collected monies. That reasoning has been extended to cases involving monetary penalties or fines associated with immigration, which is another area where Congress has plenary powers. Other examples of public rights are relations with Indian tribes, administration of public lands, granting of public benefits, and parental rights. The court in this case is really careful to go out of its way to say the public rights exception is just that. It's an exception and it needs to remain that way. And constant expansion, it would soon swallow the rule to which it's an exception. The court then turns its attention to a 1989 case, and I'm going to butcher the pronunciation of this, so I apologize, but it's the Gran Financiera versus Nordberg case. That case involved a statutory action for fraudulent conveyance in bankruptcy, and the question there was the adjudication of that action by a bankruptcy judge without a jury. Fraudulent conveyances were known at common law. In 1984, Congress amended the bankruptcy code to allow non-Article III bankruptcy judges to hear cases on fraudulent conveyances. The court ruled that was improper. Traditional legal claims must be decided by courts, and fraudulent conveyances are exactly that. They're traditional common law claims. The court performed a historic survey of English cases and showed that fraudulent conveyance were quote unquote quintessentially suits at common law. Looking back to the Jarkesy case, the court basically says that Gran Financiera decides this. Even when an action originates in a newly fashioned regulatory scheme, what matters is the substance of the action, not where Congress assigned it. Responding to the SEC argument, the court says that it doesn't matter that this was created that this claim comes out of a newly created statutory scheme. If an action resembles a traditional legal claim, its statutory origins are not dispositive. Some of you that follow Supreme Court might be wondering how this could possibly square with the 1977 Atlas Roof decision involving OSHA. The court took time to address that. They say that the public rights exception as construed in Atlas does not extend to these civil penalty suits for fraud. OSHA authorized the Secretary of Labor to promulgate safety regulations, and it empowered the OSHA Commission to adjudicate those. Unlike here and unlike in Gran Financiera, those claims were not known in common law. They're entirely administrative and statutory based. So when Congress creates new statutory public rights, it may assign the adjudication of those to an administrative agency with which a jury trial would be incompatible without violating the Seventh Amendment. That case does not extend the public rights doctrine. It merely applied it to actions that were not suits at common law or in the nature of such suits. So moving on, looking at what might come of this before we move on to the next case. When discussing Jarkesy over the summer at a firm meeting, one of my colleagues emphatically declared that Jarkesy was not a Seventh Amendment case. It was a separations of power case. I think he was right. And I think that's evidenced by Justice Gorsuch's concurrence, which asserts that the SEC's in-house adjudication seeking civil penalties also violates the Article 3 of the Constitution, as well as the Due Process Clause of the Fifth Amendment. So it seems like Congress is going to have a difficult time creating statutory schemes allowing for agency adjudication, given the prevalence of private rights versus public rights and the notion that any cause of action traceable to the 18th, 17th, and 16th century common law causes of action cannot constitutionally been taken away from an Article 3 court. Frustratingly, Justice Gorsuch in his concurrence doesn't offer a plan to expand the already overwhelmed and bogged down judiciary to help handle this, what we assume will be an added load. This issue was noted by Justice Sotomayor in her dissent, in which she said that Jarkesy was a power grab by the courts and that it prescribes artificial constraints on what modern day adaptable government must look like. When researching kind of what the outcomes of this might be, I came across an interesting article by Professor Robert L. Glicksman from GW Law School up in DC. He actually wrote an article saying that he thinks environmental law will be largely unaffected by Jarkesy and I guess sort of the in-house adjudication of environmental claims. Glicksman argues that the court here failed to really provide any useful guidance for lower courts, and they left lower courts to determine on a case-by-case basis which civil penalties are constitutionally permissible in administrative adjudication. Courts moving forward will need to determine whether in some amorphous way the statutory claim before them resembles a common law cause of action to which the right to the jury applies. The difference here for Professor Glicksman, though, is the different underpinnings of the SEC claim in most environmental statutes. Public nuisance is likely the closest common law analog to most claims brought under environmental statutes, such as the Clean Water Act or the Clean Air Act. And despite that, the theories of nuisance underlying those major environmental statutes are very specific and seemingly very different from the ambiguous nature of common law nuisance claims. So Professor Glicksman is sort of relying on that difference to try and say that the environmental statutes are sufficiently different that they can't be traced to common law, and thus in-house adjudication of claims might still survive in a post-Jarkesy world. In the interest of time, I would go ahead and move on to the next case. Next, we're going to be talking about Loper Bright versus Raimondo, Secretary of Commerce. The question presented in that case was whether or not Chevron should be overruled or clarified, and I will go over quickly what Chevron is again in a bit. The legal background here. So dialing it way back to the Constitution, the framers envisioned that the final interpretation of laws would be the quote unquote proper and peculiar province of the courts. Courts have always had the job of interpreting the law. There's always been a history of respect to executive branch interpretations of the law. Respect for executive interpretations is always highest when the interpretations are roughly contemporaneous with the enactment of the statute and remain consistent over time. But then fast forwarding a century or so, the New Deal happened, and that was really scary. The administrative state absolutely exploded. But at that time, courts still understood that questions of law were for courts to decide independently. In 1936, the St. Joseph Stockyard case established that courts could treat agency findings of fact as binding, but that questions of law, again, were still left to the courts. And going back to everyone's leg reg class or admin law from 1L, in 1944, this court decided the Skidmore case, which basically stood for the proposition that agency interpretations and opinions based on specialized experience consisted a body of experience and informed judgment to which courts and litigates could properly resort to for guidance, even on legal questions. And judicial deference there was still cabined to fact-bound determinations. Skidmore established that the weight of an agency's interpretation depended on the thoroughness of the agency's consideration, the validity of its reasoning, and its consistency with earlier pronouncements. Then in 1946, Congress passed the Administrative Procedure Act, the APA. The APA states that courts must decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. According to Chief Justice Roberts, the APA merely codified the proper role of the judiciary that everyone understood at the time. Courts have always had the obligation and the authority to answer legal questions without deferring to agency interpretation. The APA provides no deferential standard for courts to apply in answering legal questions, but it does in Section 706 of the APA, which requires judicial review of agency policy making and fact-finding to be deferential. The omission there to the court is very important, and it seems to be intentional. Congress could have included similar language when discussing questions of law, but they didn't. Some statutes expressly delegate interpretive authority over a specific term to the agency implementing the statute, and that's fine. When a statute delegates discretionary authority to an agency, the role of the reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress, subject to constitutional limits. Finally, then in 1984, the Chevron case happened, and that was a remarkable departure from the traditional approach discussed before and codified under the APA. Chevron established a two-step framework that required courts to defer to a federal agency's interpretation of an ambiguous federal statute. Step one requires the court to determine if Congress had directly spoken to the question at issue. If intent was clear, then the inquiry ends there. If the statute was silent or ambiguous, you move on to step two. Step two requires a court to defer to an agency interpretation as long as it is permissible, even if the court itself disagrees with that construction. And then in 2001, the Meade case added a step zero, which required courts to first determine if Congress had delegated authority to the agency to make rules carrying the force of law at all. Okay, moving on to the specific facts at issue here. I knew nothing about any of this, so hopefully neither do you. The regulation at issue here related to the Magnuson-Stevens Fishery Conservation and Management Act, which was passed in 1976. That created the exclusive economic zone, which is a 200-mile nautical mile zone extending out from the U.S. border, over which the U.S. has total fishery rights. It's managed through 8 regional fishery councils, and those councils develop what are called fish management plans, which have things in them such as catch limits. At the center of this litigation, though, plans may also require that one or more observers be carried on board domestic vessels for the purpose of collecting data necessary for the conservation and management of fisheries. Traditionally, those observers are paid out of federal costs. But what ended up happening here is that the New England Fishery Council ended up promulgating new fish management plans, pushing some of that cost onto private companies. Companies pushed back. The petitioners here are family-owned fishing businesses in the North Atlantic zone. In 2020, they challenged the new fish management rule, and they argued that the MSA doesn't authorize the NMFS to mandate that they pay for observers required by a fishery management plan. The district court granted summary judgment to the government, arguing that the statute wasn't ambiguous and that the MSA authorized the rule. And even if it was, petitioners' arguments didn't create ambiguity. And so the court would end up deferring to the agency regardless. The First Circuit concluded that the agency's interpretation was permissible, but they didn't really specify what step under Chevron they were deciding the case on. So moving on to the reasoning of the Supreme Court here. Right off the bat, the court makes the strong pronouncement that Chevron defies the command of the APA, that the reviewing court decide all questions of law and interpret statutory provisions. Therefore, Chevron goes beyond the traditional respect afforded to the executive branch. It demands that courts mechanically afford binding deference to agency interpretations, including ones that have been inconsistent over time. This conflict cannot be reconciled by the presumption that statutory ambiguities are implicit delegations to agencies. That's a big part of the dissent's argument here. Ambiguities happen for a lot of reasons, including simply bad drafting, and a lot of them are unintentional. Courts deal with ambiguity in cases that don't involve agencies, and in those instances, they rely on their own statutory interpretation. In all of those cases, there are quote unquote best readings of statutes, and those apply everywhere except for in a Chevron case where a permissible interpretation can trump a best interpretation. The court takes time to respond to each of the government's arguments here. So first, expertise. Courts are the experts on statutory construction, not agencies, and these are ultimately questions of statutory construction. The respondents and dissenters maintain that Chevron applies even in cases when an agency's technical expertise is not implicated. Even if the question is technical, Congress intends for courts to handle technical statutory questions. Courts answer technical questions with the benefit of a record all the time, and that's very consistent with Skidmore. A lot of people, proponents of Chevron, will argue that it helps create uniform construction of law. The court here says that the opposite is actually the truth. Judges apply Chevron very inconsistently, and so it really hasn't helped with uniformity. Further, there's no value in uniformly interpreting a statute if the interpretation itself is wrong. Interpretation of ambiguous statutes is not policymaking. Resolution of statutory ambiguities involves legal interpretation. It doesn't suddenly become a policymaking exercise because the court has an agency interpretation to fall back on. It's important to note that Congress can delegate discretionary authority onto agencies, and when that happens, judges need only fulfill their obligation under the APA to independently identify and place boundaries on that delegation. Over the last 40 years or so, courts have placed restriction and limits on Chevron. An example of this is the step 0 that I mentioned earlier from the Meade case. Chevron doesn't even apply in situations of quote unquote deep political and economic impact. Chevron also doesn't apply to agency interpretations of judicial review provisions, statutory schemes not administered by the agency seeking deference, and it's unclear if it applies at all to criminal applications. Looking at the present case at issue, the First Circuit failed to apply step 0 and refused to clarify even if it was deciding under step 1 or 2 of Chevron. The Supreme Court itself has not once deferred to an agency interpretation under Chevron since 2016. Some of you, like me, when hearing about this, might wonder about stare decisis or the basic structures of common law system. Chief Justice Roberts says not to worry. Stare decisis is not a command. And here, the quality of the precedent, the workability of the rule established, and the reliance on the decision all support overturning Chevron in despite of stare decisis. It's the direct quote here is, given our constant tinkering and eventual turn away from Chevron and its inconsistent application by the lower courts, it is instead hard to see how anyone, Congress included, could reasonably expect a court to rely on Chevron. So Chief Justice Roberts asserts that Chevron fosters unwarranted instability in the law, leaving those attempting to plan around agency action in an internal fog of uncertainty. Therefore, Chevron has served to undermine the very rule of law that stare decisis exists to secure. Stare decisis does not require the court to rewrite Chevron in a workable way, so they don't here, which leaves open the question of what we fall back onto. Despite saying all of that, and I think this is really important to note, and this is something that we'll explore later in the Q&A portion, Chief Justice Roberts says that they are not calling into question prior cases that relied on the Chevron framework. The holding of those cases that specific agency actions are lawful are still subject to stare decisis, despite the change in interpretive methodology. So briefly talking about next steps before handing over the mic, commentators have stated that after the quote unquote death of Chevron, courts will necessarily fall back to Skidmore deference when evaluating whether to give deference to an agency interpretation of a statute. I think that's likely true, and we'll likely start to see that. When looking for cases applying Loper already, I have yet to find one explicitly using Skidmore, but it hasn't been very long. Courts and politicians are already hard at work trying to respond to this decision. Senator Ron Wyden from Oregon drafted new legislation actually codifying Chevron-type deference. That's the Restoring Congressional Authority Act. The bill would amend the APA to include judicial deference to agencies. As of August 1st, the bill has been read twice and referred to the Committee on Homeland Security and Governmental Affairs. Representative Jayapal Pramila from Washington authored the Stop Corporate Capture Act. That similarly has been referred to the House Judiciary Committee and the Oversight and Accountability Committee back in March, which actually predates this decision, but deals with some of the same underlying concerns. On the other side of the aisle, Senators Bill Cassidy of Louisiana, Tom Cotton of Arkansas are working on a bill calling for oversight of agency action and clarification of agency regulation. That's the Bureaucratic Overreach Review Act, and that would require a review of past decisions decided under Chevron, which seemingly goes against what Chief Justice Roberts was just saying regarding stare decisis. Quickly looking at Fed court action, I found a couple cases applying Loper already. So in August, the DC Circuit Court applied a Chevron type deferential standard to a dispute over the interpretation of a contract administered by the Office of Personnel Management. This Chevron type contract deference came from the 1987 decision National Fuel Gas Supply Company versus FERC, which held that a court generally must give deference to an agency's reasonable interpretation of an ambiguous contract. The DC Circuit did note that there's seemingly some tension there between that type of deference and Loper, but they they avoided directly resolving that tension. Also in October, the DC Circuit again had opportunity to revisit the contract deference question in NextEra Energy versus FERC. That case involved a FERC decision to require a nuclear power plant owned by NextEra to perform specific upgrades under a contract titled Large Generator Interconnection Agreement. The court sidestepped directly answering the Chevron question, but held that FERC's interpretation of the applicable contract was correct. The dissent in that case did make a lot of noise about how that went against Loper. And then moving on, the Fifth Circuit recently just struck down the Department of Labor's 80-20 tip credit rule, and they cited Loper to do that. The Fifth Circuit found under Loper that the Department of Labor's interpretation was owed no deference and was contrary to the text of the Fair Labor and Standards Act. So those are just a quick examples of ways that courts have already been using Loper, or in the case of the DC Circuit, not using Loper, but intelligently sort of sidestepping it. In the interest of time, I think I will go ahead and pass the microphone over to April now and leave some of this for follow-up questions.
Thanks, Jack, and good afternoon, everybody. So I am going to quickly provide an overview of the corner post decision. We all felt we couldn't really have a discussion about Loper Bright without also talking about corner post. So I'm going to share my screen, pull up a few slides. The full opinion here, it's corner post versus the Board of Governors of the Federal Reserve System. If you haven't read it yet, I highly recommend you do read it. It's not a super long case, but it's got just some interesting analyses from Justice Coney Barrett here at the majority decision, as well as from the concurrence by Justice Kavanaugh and the dissenting opinion as well. So to kick this off, if I can get my slides to work. There we go. So here's the background. So back in 2011, the Board of the Governors of the Federal Reserve System promulgated a regulation that set the maximum interchange fee that banks could charge to merchants for debit card transactions. So if any of you've ever been in a gas station, you've used your debit card and there's a sign that says, there's this fee that applies. I think that's generally what they're talking about. So that rule was challenged shortly after it was promulgated. And in 2014, the DC Circuit rejected that facial challenge to this regulation under the APA. And the DC Circuit held that the court had to defer to the board's reasonable determination that the underlying statute, which was the Dodd-Frank Act, allowed those fees that banks would charge to those merchants. So the rule was valid, it was in effect. Now in 2018, Corner Post opened. Corner Post is sort of like a gas station type of convenience store. There's a photo of an example of one on the slide. So they opened in 2018 and began paying those interchange fees. And then in 2021, they brought another facial challenge under the APA, challenging the legality of those fees. So this case hinges on the timeliness of the lawsuit. So the Eighth Circuit, the courts through there ultimately dismissed the claims as untimely. Under the APA, suits against federal agencies have to be brought within 6 years after the right of action first accrues. And the district court and then the Eighth Circuit both held that the 6-year statute of limitations period under the APA begins to run upon the publication of the regulation in the Federal Register. And because that regulation was published in the Federal Register in 2011, the statute of limitations expired in 2017, and the suit was just too late. This established a circuit split. So I think 5 other circuit courts had agreed with the Eighth Circuit and ruled that the statute of limitations under the APA begins upon the date the rule was promulgated. The Sixth Circuit, however, had gone the opposite way and had ruled that the statute of limitations for APA claims actually begins when the plaintiff suffers injury. So that was really the argument that Corner Post was hanging its hat on. So this was appealed to the Supreme Court, and in a 6-3 majority or a 6-3 decision, the Supreme Court agreed with the Sixth Circuit. So the majority held that the right of action first accrues under the APA, not when the rule is published, but when the plaintiff is injured by the agency action. Justice Coney Barrett wrote the majority decision. I think I mentioned that. She spent a lot of time distinguishing between statutes of repose and statutes of limitations. And I'm assuming everybody sort of remembers this from civil procedure, but just to give a reminder, the way that she framed the two, she explained that a statute of repose sets a limited amount of time to bring a claim that's measured from the date of the last culpable action or omission of the defendant. So it's the defendant's actions or inaction that triggers the limitations period in a statute of repose. A statute of limitations, in contrast, creates a time limit for bringing a case based on the date when the plaintiff's claim accrues, which she said is when the plaintiff is injured. So in this case, because Corner Post sued within 6 years after being injured by having to pay those interchange fees, the Supreme Court held that the case was timely and remanded it back for rulings on the merits. So there are a lot of kind of key takeaways here, and in my opinion, this case may be even more, I'm trying to think of the word I'm looking for, impactful than Chevron. So first, this significantly expands opportunities for APA challenges to regulations, to facial challenges to regulations that have stood for decades. So including all of those regulations that have been upheld by Chevron deference. This opens the door for people to come in and challenge those regulations now. New challengers can avoid legal precedent by potentially filing in different circuit courts around the country, so we can get sort of competing rules, different outcomes of different circuits. One thing to note, this applies to facial challenges. Plaintiffs can still bring as-applied challenges in response to enforcement actions by federal agencies. So this really does concern facial challenges. One thing I did want to highlight that I thought was interesting is that the majority assumed without deciding that the vacature of federal regulations is a remedy under the APA. I think that's a topic that's been, kind of up for debate in recent years. So this really does at least indicate where the Supreme Court is going to go on that issue, on that question. And Justice Kavanaugh's concurrence really gets in the weeds on why he believes that vacature of federal regulations is a remedy. So if that's something that you are interested in, I highly recommend reading his concurrence. In the dissent, Justice Ketanji Brown Jackson, she had a lot of warnings of how this decision is going to affect all of us kind of moving forward. She said this decision is going to allow well-heeled litigants to game the system by creating new entities or finding new plaintiffs whenever they blow past the statutory deadline. That's essentially what Corner Post did. She cautioned that it will wreak havoc on government agencies, businesses, and society at large, and will lead to a tsunami of lawsuits. We'll have to wait and see if any of that comes to fruition. But I generally agree with her that this does open the door for significantly new challenges to regulations, both in the past and in the future. So for those of us in the environmental sector, this is an environmental law section talk. I did want to highlight some of the statutes that a lot of us deal with on a regular basis. So here on the, I guess, left side of the screen, these are environmental statutes where the limitations period is governed by the APA. So for anybody who wants to bring a claim under the APA for violations of these statutes, the time period begins to run from the date the plaintiff is injured. The statutes on the right side of the screen, they all have separate limitations actually identified in the statute themselves. So if you're planning on filing a lawsuit or defending against a lawsuit in these under these statutes, make sure you go and actually read the language of the limitations period. If it's a statute of limitations that mentions when the claim accrues, you're probably going to want to follow Corner Post and start measuring that time period from the date the plaintiff is injured. Otherwise, there could be some more statute proposed type language that, requires you to file from the date an order is entered, for example. So just make sure you're reading the language of your limitations periods and making sure that you're being careful as you move forward so you don't accidentally miss statute of limitations period. And I think that's all I have on this case. And so we can, however you all want to turn it over to questions or panel discussion.
Perfect. I think, Professor Siegel, if you are prepared, I think we'll go ahead and do your remarks now, and then that way we'll have the bank of time at the end to do Q&A with everyone.
Sure. Hi, everybody, and thanks for having me. I am here to bring a pessimistic dose of legal realism to the room, because that's what I do in life and in work. And November 16th, 2016, 8 years ago, I wrote the following about a few days after Donald Trump was elected the first time. What does President-elect Donald Trump care about the most? Obviously, he's going to appoint judges to deal with abortion, but after that, the answer is deregulation and freeing up businesses, including his own, from safety, environmental, and other workplace rules imposed by the national and possibly state governments. Sadly, there is no shortage of judges and nationally known academics who might be willing to dismantle these regulations. That's what has happened. That was 8 years ago. And although the 3 justices he put on the court are going to be most famous for Dobbs, when time runs out eventually, I think they're going to be considered, this whole court's going to be considered the 5 or 6 horse people of the apocalypse recycled. So I'm here to tell you that we can have very reasonable debates in America in 2024 about how to govern a country with 3,000 miles and 50 states and Hawaii and Alaska and so on. I think it's an unclear thing how much Congress can actually do, but it's a scary thing to give the president so much more to do and all that. We can have those debates, and that's what you guys do, and you guys are experts in that. What I'm here to tell you is the constitutional balance that was struck in 1791, and it should be struck today, and at pretty much every moment in between on separation of powers issues, is that the political branches should decide. Absent a gross distortion of constitutional text, there's no reason for the justice to get involved here. The founding fathers gave George Washington effectively $1 million and said, do what you want. Now people are going to say, well, that's because he was George Washington. No, that's how they viewed administrative agencies back then, even. So I do want to really quickly get this out of the way. There is no originalist basis to any of this. It is all living constitutionalism on steroids. Now, the Jarkesy case and the Sixth Amendment and the jury trial issue is different. Let's just put that out of the way. That's not really an administrative law issue. It is, but it's more a constitutional issue. Don't worry about that one. And the statute of limitations, obviously Congress can change that. So that's not a constitutional issue either. But the major question doctrine, the uber formalist decisions by the court about the firing of agency officials and heads, in light of complete textual absence of any limit in the Constitution on that, and all of the deregulatory steps the court has taken are policy choices, and they are modern and they are current policy choices. And even if they weren't modern and current policy choices, they would have to be, because in the most famous, so all of this involves separation of powers. We want the government to be efficient. I want the government to be efficient. Everyone in this room, all 90 of us, want the government to be efficient. I assume all 90 of us also want to avoid tyranny. In every separation of powers case, almost, that's the balance. So we want the president to protect us from terrorism, but we don't want him to be a dictator when he does it. We want to have an efficient judicial system where non-Article 3 judges can decide administrative cases, but we don't want to sap away too much power of the independence of the Article 3 judges to avoid tyranny, and so on and so forth. That's every case. That balances every case. And in the most important case ever on those issues, probably, the Steele seizure case back in the 1950s, Justice Jackson, who I think is pretty much universally recognized as an excellent moderate judge, we may have issues here and there, but he's not a Scalia or, Ginsburg or whatever. He basically said this, and it was true then as it was truer then than it is today. Just what our forefathers did envision or would have envisioned had they foreseen modern conditions must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. A century and a half of partisan debate and scholarly speculation yields no answers. That's true today, too. If you want to go back and look at history, you could always find some corner. But here's the deal. If you're ever litigating as a constitutional matter, the kind of the issues involved here, Julius Morton Stern and Nicholas Bagley wrote an amazing article that shows without any doubt that there's no originalist bite to any of this. There just is, this is not what the founding fathers thought. I don't care whether it was or not, and neither should you, because now we're 3,000 miles in 50 states and not 13 states on the East Coast, and now we have an internationally connected economy. And back then we didn't even have the Industrial Revolution yet. So to care about it is stupid. But if you're going to care about it, then read that 100-page article, and you will see that not in 1937, but in 1795 and 6 and 8 and 1801, they gave the executive branch so much authority. And maybe that's bad, or maybe that's good. I don't know, but it's not unconstitutional. And the major questions doctrine, the reversal of Chevron, the major questions doctrine, all of this was predictable as a matter of legal realism. It just was. I did it in 2016. And it is predictable also as a matter of constitutional cycle. So I'm not going to, I know people want to ask questions about specific cases and do all that. I'll just say this. One way, if you don't like what the court is doing in administrative law, / constitutional law, especially if you're an originalist, which probably very few of you are, but it's all anti-originalist. If you really care about this, then we've got to stop disguising it with legal terms. The court is imposing its libertarian preferences on America. The Warren Court, put its liberal preferences on America. This is how it works. And that's what they're doing. And that's all they're doing. And we can talk legal doctrine. You have to do that. And when you go to lower court judges, talk the talk and walk the walk. But you should also drop in there, Your Honor, do you really want to be deciding the balance of power between the Congress and the president on like a monthly basis in the federal courts? What a dumb idea that is. That is not for judges. That is for the people. And if we don't like what the federal government is doing, we can change the federal government. When I was in law school in 1980, no one saw the Senate going red. We all knew Reagan was going to win. No one saw the Senate going red. Obviously, our last election. We can change it if we want to. We don't need Justice Roberts opining about agency heads and how they have to be independent. That's crazy. So my advice would be for those fighting this, stop playing their game and just say, this is not based on text. There's no text about this. There's no text about firing officers. None, zero. There's no text about the major questions doctrine. Don't talk text, history, and tradition, or do all that, and then at the end say, but we should really rethink eventually as a society what the court is doing here, because people can vote, and no one's constitutional rights are being violated in these cases, and it's just the justices imposing a regulatory state that they prefer, a deregulatory state that they prefer on the rest of America. And if anyone wants to think this is just a bleeding heart liberal talking, I will tell you, I am pro-choice, radically so. I would vote for a constitutional amendment enshrining abortion, the right to choose in the Constitution. I believe Roe and Casey have been wrong my entire life. So I don't want the court doing that. I don't want the court doing this. I want the court to back down unless text is clear and history is uncontested. And in administrative law, there's usually no text and the history is incredibly contested. That's the constitutional bad news for the day. Thank you very much.
Thank you, Professor Siegel. That was fantastic. just to start us off, I have a couple prepared questions, and then I think we will turn it over to the audience to solicit questions also. So we were just looking at it from a 3,000-foot view. To dial back in quickly, though, focusing on corner posts first, do you think, and I think this, well, this is obvious at one level and maybe not obvious on another. Do you think corner posts could lead to situations in which people or companies create new organizations simply for the purpose of being, quote unquote, harmed by final agency action that is
It already
otherwise?
happened, John. I'm sorry to interrupt, but it already happened. The abortion case last term was brought by a group of doctors who got together solely to bring that case.
Yeah, and so I guess my question was whether or not you think this could usher in a new era of that being more common. Was this the court sort of signaling, yes, please go ahead and do that? And then my flip side to that is this could sort of benefit both companies pushing back on agency regulation as well as public interest organizations having more opportunity to push back on what they might see as inefficient or insufficient regulation.
Let me just say, standing is the issue I've written the most about in my career, other than this court generally, and I teach standing in federal courts over 6 weeks. Never make the mistake that one standing case leads to the next. It never does. So in the LA Times, I said standing is what standing does, and that's true. So this term was about the election, and they got rid of the standing of that group because they didn't want an anti-abortion case right before the election. It's not more complicated than that. They'll bring it back eventually with a different group of people. But just my only contribution here is the court can find standing or not find standing anytime it wants for whatever reason, depending on how they view the merits. Period. Full stop. If you're a defendant, always argue it. If you're a plaintiff, always defend it.
Yeah, and I agree. I think, we will also see, new companies being formed, new, groups being formed for the sole purpose of challenging, an agency regulation in a different circuit if it lost another time. So yeah, I do anticipate seeing that.
I mean, I don't know how many, I agree too. I guess we're all in like heated agreement over this one, but I guess to Professor Siegel's point, I do think it's worth noting that any decision can be both good and bad for any group of people. I mean, even if you take a step back, Chevron, right, was ruled against the NRDC. So it was a Reagan regulation that was upheld. Then you saw later kind of the flip side where the more liberal folks were arguing that it was a good decision, and it goes back and forth from there. So I think what we'll see is what we've always seen, folks using the law to the extent that it benefits their clients and arguing that it's inapplicable to the extent that it doesn't.
I'll just say, I agree with Mindy 100% on that. I will say, even from a core legal realist, let me put it this way. My legal realism is disputed by hundreds of law professors all over the country. No one disputes that standing is incoherent to the court. Like there's no one out there defending standings. People defend Dobbs, people defend colorblindness, people defend this and that. No one defends the court standing charge.
In response to one of the Fed's arguments in this case, the court says, quote unquote, pleas of administrative inconvenience never justify departing from the statute's clear text. Do you think that corner posts will result in large amounts of administrative inconvenience?
I'll go ahead and take a stab at that really big question. And I should say that quote actually comes from a previous decision. I want to say maybe 2018 decisions regarding the immigration and process and filling out really complex forms, both the government and the person. And so that's where it comes from, right? And I don't think that's wrong. Like this stuff is tough. The administrative process is tough. There are complex administrative schemes that are difficult for both the regulated parties and others intervening. I don't think that this court is interested in making stuff easier for agencies. I don't think that is its North Star. I don't think that's something that they're considering when they're reaching these decisions. And so maybe they said the quiet part out loud, but I don't think they ever were really going to think about, well, is this going to make stuff easier or harder for this agency when reaching a decision? Those were never going to be convincing arguments for this court. And so I think it's kind of a continuation of where they were heading.
Well, we'll see, Mindy, because I do think it's going to be very interesting to watch what they do in the next 4 years. And so real quickly, if I may, before the immunity case, we all thought, we knew the court was Republican because it's a Republican court, but we didn't know if it was a Trump court. We didn't know that. Like many of us thought it wasn't. It turns out it's a Trump court. So are they going to make agency action harder in the next 4 years? I'm not sure. It'll depend, like it always does, on what the agency action is.
I think
If
that's a different question. That's, are they going to uphold agency action or not? That's a results question, not a process question.
But it will end up with significant impacts right in the litigation in the lower courts, what they decide.
Yeah, yeah.
I don't think this would be a great experiment, but I don't think they're going to make it incredibly easy over the next few years to challenge executive action compared to the last 4.
As is often the case with today's court, Justice Barrett ended the corner post decision by saying that the ball is in Congress's court here, and the solution is for Congress to enact a distinct statute of limitations for the APA. Do you think the court is punting on that question, or do you think that's a legitimate response?
I mean, when is Congress going to act? I mean, Congress is, dysfunctional at best. I think, it was just to kind of wash their hands of it because. I mean, it is, to be fair, it is a fair point. Congress could change it. Will they change it? Unlikely.
Congress could change all of this theoretically.
Exactly.
Not all of it, but almost all of it. At the end of Shelby County, Justice Roberts says, hey, Congress can change this. He knew exactly what he was doing.
So yeah, I guess my answer is, I think you presented the question, Jack, as an either or, and I think the answer is it's a both and. It is both true and a way for the court to get out of wrestling with some of these questions.
Technically true.
Well, staying on the focus of how awful Congress is at their job, moving on to Loper, Chief Justice Roberts and Loper dismissed one of the dissent's arguments about ambiguous language by saying that ambiguity happens for many reasons, such as bad drafting, and it shouldn't be read as an implicit delegation to agencies. Despite that pronouncement, presumably agencies have been operating under the assumption that those ambiguities are delegations since the Chevron decision. So do you think that Congress will now be more intentional with its drafting? Do you think Congress will even care?
I think your question really is, will the committee members who draft the legislation pay close attention
Yes.
to? Don't let the audience think Congress people get involved in any of this in terms of drafting, because they don't. And yes, I think they will. I think those people are trained to pay attention unless Trump fires them all somehow, even that would violate separation of powers.
Yeah, I will also say though, so I mean, part of what I do is legislative work, right? So I work with legislators on crafting legislation, and my like 99% of the time, I want a bill to be as clear as possible. I don't want a misplaced comma or an undefined term to create ambiguity. But sometimes legislators want ambiguity, and there can be a strategy for it. And so I really think it's going to depend on what Congress is trying to legislate and what their desired outcomes are, because they might want to say, hey, we took action on something, knowing very well that it's going to get challenged or there's going to be ambiguity, and we don't know what the real outcome is going to be. So we'll see.
Yeah, I think that's right, April, and I agree completely. The other thing I will note is, at least for reading between some of the lines in Loper Bright, there seems to be an opening the court left for express delegation of authority to the agency to do some of this interpretive work. And so I hear you, Professor Siegel, but perhaps what we'll see is the use of words appropriate and necessary and whatever other magic words the court threw in by these staffers in an attempt, whether or not it's a successful one, to carve out some authority for agencies to fill in the gaps.
I'm sorry.
Oh no, go for it.
The next shoe. So many of us were always wondering when the spending power shoe was going to drop after the Rehnquist Revolution in the 90s, and it finally dropped in the NFIB case in 2012, where they totally changed the spending power. The next shoe that's going to drop on all this is Commerce Clause. And what you guys are going to be fighting about 4 years from today is not the power of administrative agencies, it's the power of Congress. And that's what you're going to be fighting is the next time an agency does something pursuant to a statute that's a liberal thing that the court doesn't like, and the statute clearly gives them the authority to do it, the court is going to say Congress can't give them the authority. That's what's going to happen, even if they want to. That's the next shoe to drop. So 4 years, I'll see you guys 4 years from now, and we'll continue this discussion.
So I don't have the site handy for this, but looking at Georgia, in the past, the Georgia Supreme Court has said that agency to or deference to state agencies in Georgia is quote unquote in accord with Chevron. This past summer, Judge Dillard of the Georgia Court of Appeals, in a concurring opinion, sort of bemoaned Chevron's application in Georgia and called for the Georgia Supreme Court to reverse or to explicitly do away with Chevron deference in Georgia. So I guess, do you think we might see something like that happen, or do you think we might see a similar trend at the state level with states trying to do away with agency deference also?
The governor of Georgia, I would think, does not want to do away with agency deference. That being the case, I'm not sure. Judge Dillard is wonderful. He's a good friend of mine, and he loves constitutional law. So it's not surprising to me that he's really a good guy. But I do think the politics in Georgia are different.
Yeah, I agree with that. I'll also add that was my case. And it's we have filed a petition to the Supreme Court, so we'll see if the Supreme Court bites on it or not. So we might have an answer for you, within the next year on at least in that particular case, whether it yields something. But yeah, I think it remains to be seen.
One more question before I open it up, just so we hit all the cases, moving to Jarkesy then. And the court kind of discusses this a bit. Do you think Jarkesy will push administrative agencies to rely more on informal proceedings, or rather than formal? Sorry, I completely misread my question here. My question more is about, do you think Jarkesy will push administrative agencies to pursue equitable remedies rather than legal remedies like civil penalties? Will they look to act through equity more than actually pursue claims for legal claims in court? And so I guess I'm thinking about this largely in a permitting type situation.
I think it'll depend what the case is about.
Yeah.
Yeah, I mean, most of what I do is seeking injunctive relief anyway, so it's something that I haven't given honestly a ton of thought to. But it's an interesting question.
Bankruptcy judges do jury trial. I mean, the whole that. So I will say this: Judge Posner, who I used to talk to all the time, he's now very sick, used to scream at me all the time about $20, and he would curse. What a stupid freaking thing that is. Because he didn't believe we should care about 1791. I think $20 is a ridiculous amount. That's what I think.
Well, we have about 2 minutes left here, and I did promise everyone a Q&A portion. So it seems as though one lucky audience member will be able to ask a question and get a response here. So if anyone does have a question, I don't know if the easiest way to do this is to raise your hand or to throw it in the chat if you're brave enough. And if no one does, I have some more questions I can flip back to for the remaining time. Okay, well, I will take that as a no for now, so we don't have to sit longer in awkward silence. At least it was awkward for me. It probably wasn't for all of you. I guess I think we did really hit everything. I have some larger questions here that were meant to prompt a broader discussion, and they're really thought out, such as, do you think this is a big deal? So rather than turning to that, I think I will give the panelists an opportunity. Do you guys have any closing remarks or thoughts or anything you would want to leave us with? Sorry to put you on the spot.
I would just say that as someone who has studied constitutional law for a very long time, just don't, the project, for at least, I think, for people who litigate these kind of things, who don't like what the court is doing, try to put in words that show this is not a serious thing. This is just values. There's no text. They don't cite text in these cases. They don't cite history. They just cite values. And this is allegedly the most originalist court ever, which it's not. But I'd fight back on that plane. A true originalist would be deferential to what Congress thinks is the correct separation of powers balance between Congress and the president. And an originalist court would only step in where there's a clear violation. I don't believe there's a clear violation in any of these cases. I'd rather them come out and say, we're libertarians. We think it's bad when the federal government regulates and we're going to stop it. Then we could have a real debate. That would be a real debate. Like, I like to have that debate. We're not having that debate.
I'll just answer your question, Jack. Do I think this is a really big deal? And I guess my answer is yeah, I do. I think that whenever the Supreme Court issues decisions, it's a big deal. When we see a switch in the court away from longstanding precedent, that's a big deal. And I think this will have real impacts on all sides of the issue. As professors, there's a lot for us to talk about with our students. I think there's a lot of opportunity for lawyers to play a big part in the application of these decisions. But yeah, I think it's a really big deal.
I think talking the talk while walking the walk of how stupid this is the way to go. You got to talk the talk to win the case. But you should also, that's what the conservatives did for 30, 40 years on abortion, right? Even judges who would strike down laws, they would say, you know, we have to strike this down because of Roe and Casey, we don't want to. I mean, it's okay to do that. And it's okay for litigators to say, Your Honor, you're stuck with the Supreme Court's decision here, and I'm sorry about that. I think it should be done narrowly for these reasons, you know, and also remember that we shouldn't be in this game at all, but we have to be because of the court. That works over time.
Yeah, I don't think I have any other words of wisdom to add beyond what Eric and Mindy just said, but it will be a very interesting next 4 to 10 years, I think, in this space. So.
Well, great. Thank you, everyone, for joining us today. I see that we're now past 1 o'clock. So thank you again. And if you have any questions, please feel free to reach out to me via email, and I'll do my best to respond as quickly as possible. And thank you again for joining. I hope you learned today.
Ladies
Everyone,
and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.